I have the honor of welcoming our speaker, who we were lucky enough to have speak with us last year as well. We have Judith Flynn with us today, who's a certified elder law attorney. She's a shareholder at Falco and Associates, and she continues to advocate for elders and their families in all aspects of elder and special needs law and estate planning. She serves on the executive committee of the National Academy of Elder Law Attorneys, currently serving as president, and she also served as president of the Massachusetts chapter in 2014. Judy has served as co-chair of the NAELA's State Advocacy Committee since 2019, working to advocate for the rights of seniors and individuals with special needs at the state and national level. Please join me in welcoming Judy, and I will bring up my slides. And just as a note to people, Judy has graciously agreed to share her slides with the group after the presentation, so those will be sent to you tomorrow. So don't worry about taking feverish notes during this presentation. You will have access to all of that information. And take it away, Judy.
All right. I'm not muted, right?
Nope.
Okay. Thank you, Kyle. Thank you, Chris. And thank you for the honor of being here again. It's such a wonderful group. You provide great resources to the community. So the slides that I have, when I attend a presentation, when I get bullet point slides after the fact, I don't find them very helpful. So you have a ton of dense information in the slides that you'll receive. I find that to be more helpful. It's basically talking about a multidisciplinary approach to estate planning, laying the foundation with legal documents and estate plan that everyone should have, and some various options that people can consider based on your personal situation. Then I'm going to go into financial guidance and how do we pay for care? What are the various options for optimizing your care dollars? And finally, case management is the third prong of that multidisciplinary approach. Things like client advocacy and care coordination, appropriate levels of care for home care, assisted living, nursing home, etc. So we'll start with laying the foundation and ensuring you have the appropriate legal documents in place. Documents that everybody should have. A healthcare proxy is the most basic, probably one of the most important. This is where you appoint a surrogate decision maker to make health and medical decisions if you become incapacitated temporarily or permanently. So who would you want to make those decisions if you become unable? You want to have conversations with this person so they know what you would want. The role of the healthcare agent is to make the decision you would make in that moment if you could speak for yourself. These by law are springing powers. The doctor has to say that you don't have the ability to make informed decisions for yourself. You're still in charge. You should get this in place while you're able. You don't lose control by doing it. You're taking control and saying, this is who I want to make those decisions if I'm unable in the future. And under the law, you cannot have co-agents. Clients sometimes have trouble picking which child would be first, second, etc. You have to make that decision. You can't have co-agents. Next document is the HIPAA authorization. This is not a medical decision maker, but it's a release of your private medical information. Who can the doctors give your information to, tell how you're doing, etc. A lot of times, clients will include the spouse and all the children or a trusted friend, whatever. So you can have several people in that, whoever it makes sense to include. And this is an immediate power. It's not springing. I want to touch on a living will. It's not currently, it's not enforceable in Massachusetts. It used to be a very generic statement drafted by attorneys. What would you want in life-prolonging situations? It's not enforceable in Massachusetts. We're one of only a few states, I think, where it's not enforceable. This is now what has taken the place is a MOLST form. If people come in with a living will, we leave them in place. It's not that it's useless just because it's not enforceable. It can provide guidance to your healthcare agent under your healthcare proxy. But what has taken the place now is a MOLST form. That's that hot pink form, if you're familiar with it, that people get from their primary care physician. That's where you're going to spell out a continuum of wishes. Some people do it at a younger age. It's not just end of life, but typically I think of it as end of life or life prolonging situations. And it's going to cover things like, do you want a DNR, a DNI? Do you want comfort care only in certain situations? And it's a continuum, and it can change over time. So if your situation changes, continuing discussions with your primary care physician, you change your MOLST form, and you can do that. Another document, I'm sorry, Kyle, can we advance? I have to remember to tell you that. Thank you. The durable power of attorney. This is a critical document, very, very important. It's where you name a surrogate decision maker or helper, someone to stand in your shoes. Does not take authority away from you. It can be a springing power where, like the healthcare proxy, you lose capacity, then your attorney, in fact, has the ability to help you under the power of attorney. Frankly, I don't think a springing power is worth the paper it's written on, because it just presents additional barriers. If your child, for example, is named under your power of attorney to help you with finances and contractual things, and they go to the bank with the springing power, usually those documents say you have to have one or two statements from a primary care physician saying that you don't have capacity. They don't want to be the gatekeeper on something like that. So it becomes a barrier to being effective when it's needed. So I only do immediate powers where you say, I, this date, appoint this person as my primary attorney in fact, and if that person's unable to serve, then this is my alternate. But I cannot stress strongly enough how powerful this document is, a well-written, durable power of attorney for elder law purposes, or for people dealing with, some chronic illnesses, Alzheimer's, other dementias. It has to have very powerful things in there. A lot of things specifically enumerated, but that makes it so powerful that I can't stress enough. You have to completely trust anybody you name in a durable power of attorney. And sometimes talking with clients, there's a little voice in their head. They know there might be an issue with their child, and they're telling me to put them in the power of attorney. I'll keep exploring that till we get to the point where we recognize maybe that child shouldn't be in this document. It's too powerful. So you can do these documents online. I don't advise it, because that's the counseling you don't get with online forms. It's really important to do these documents correctly because they're so powerful. So that's the durable power of attorney. And again, that does not take any power away from you. It just gives someone legal authority to assist you with financial and contractual things. And a tip I always give to the attorney, in fact, named in the power of attorney, is not to sign their name only. An example of that is if they're signing an admission agreement at a long-term care facility for mom or dad or whomever, the staff person who is signing all the documents with them might say, oh, just sign your name. That attorney, in fact, needs to know that is not the proper way to sign it. That can be construed as taking personal responsibility in some situations. The correct way to sign is signing the principal's name. So mom's name, for example, by daughter's name as attorney in fact, under the power of attorney. It's a lot to write, but it really is a way to provide a layer of protection for your attorney in fact. So let's move on to the next slide, please. So let's talk about probate. This comes up all the time. A lot of times people's calls to an attorney are prompted by their thought that, oh my goodness, I need a will. I don't have a will. And I will tell you, usually the will is by far not the most important document. There are situations where it is quite important, but let's go over what is probate and how do we avoid it, because in most situations, the right thing to do is to take some simple steps to avoid probate. You don't have, your family doesn't have to go through probate just because you had a will. They don't have to go through probate just because you passed away. The key question in whether probate is needed or not is, did this person die with assets in his or her name only? The way that people intentionally avoid probate is by adding a joint owner to their accounts, having a named transfer or pay on death beneficiary, such as with life insurance or an IRA, or 401k, you typically have named beneficiaries for those accounts. Those things are going to pass to the joint owner or to the named beneficiary. You don't have to go through probate to pass those assets. And the other way we avoid probate is by putting assets in trust. The trust will spell out it's for my benefit now or my kids' benefit. And then if something happens to them, it's going to pass down to these people. You have all your contingency planning outside of probate spelled out in the trust. So again, it doesn't matter if the decedent left a will or not, because in, I think, every state, but in Massachusetts, of course, we have an intestacy statute. If you die without a will, you died intestate. There's a statute that says if you died with assets in your name only that we need to get to their rightful owner, there's a statute will follow. If you had a spouse, if you had children, if you had a parent alive when you died, it's spelling out who gets what. So on that point, that's one of those cases where it might be really important to have a will if your wishes don't line up with what the intestacy statute would, how that would divide assets if you didn't have a will. So that is an example where, let's say you want to omit somebody. Your kids would take equally, your 5 children, but one of them, for whatever reason, you want to omit. Well, they're going to take under the intestacy statute if you don't specifically omit them. So that's an example. So avoiding probate is important in most cases, but there are cases where probate court can be very helpful and valuable. Sometimes families are just very dysfunctional, and court oversight might be the best thing for that family. Probate court can be your friend in that case. If there is a disabled beneficiary or something, there are certain situations where probate can help. Spousal situations I'm going to get into in a moment, but there is a special type of will we do in a marital situation where one of them has care needs that we expect to increase over time, that we can likely get mass health benefits for. There is a will that can protect the estate in that situation. So we'll advance to the next slide, please. So let's go over, excuse me, some different types of wills. First is a very simple will. Nothing extravagant. It says, who do I nominate to be my personal representative? That's the current terminology. We used to call it an executor or executrix. It's now, excuse me, a personal representative. Spells out how your assets will be distributed to your children equally, etc. Very simple. It's good to have a will, although even if the goal is to never have to file it, sometimes something is missed or there's a refund issued after death and it's payable to the estate and we can't cash that check until we have an estate account. So even if the intent is to avoid probate, a simple will is still a very good thing to have. A pour-over will, this is something that if I'm doing an estate plan that is focused on avoiding probate, we're going to have a trust involved, at least one trust. The trust, a revocable trust, is going to be the heart of the person's testamentary intent, where things will be divided amongst who gets what, but outside of probate. The pour-over will is going to be just in case something is missed. It basically says, pour it over to my trust. That's why we call it a pour-over trust. So that goes hand in hand with a trust plan, a probate avoidance plan. Next is the will with testamentary trust. That is that very valuable will I just mentioned on the previous slide. When we have a married couple, we do this type of will that under the federal and state regulations, the Medicaid regulations, assets that go through probate to this type of trust are immediately protected. Huge value in this. So for example, let's say I have a husband and wife, family comes in, let's say husband's in rehab, he can't safely come home, he needs nursing home care. We're going to advise putting the deed in the wife's name only, because we can't do a transfer to the kids at that point, that's disqualifying, but interspousal transfers are always allowed. So we're gonna put the house, maybe all the other assets can go to the healthier spouse, in this case, the wife. We don't want her at risk with, say, a simple will saying, I leave everything to my beloved spouse, because if she dies before her husband in the nursing home, now all the assets went right back to the nursing home spouse. A simple change is to put the assets in her name, knowing they have to go through probate if she passes first, but they end up in a trust that's created during the probate process, which is why it's called a testamentary trust. The trust is for the sole benefit of that nursing home spouse for the rest of his life, in this case. Can be used to supplement his care, add to his quality of life, but those assets do not count against him. Medicaid keeps paying that monthly bill. Those assets then pass to the beneficiaries on his death, presumably the children or whoever the other beneficiaries are. So it's extremely valuable. Even if this is not somebody in a nursing home, say we have a spouse that has some diagnosis, we know there's increasing care needed over time. It could pay for assisted living for that spouse. Sometimes, one spouse is only still in the home because the healthier spouse is keeping them there by the care they're providing. And we know that if that spouse predeceased, this person couldn't stay in the home and would need to be placed somewhere, maybe assisted living. So the trust can be used for whatever the surviving spouse needs, but it does not count for nursing home and doesn't disrupt the benefits. So it's amazing. So we'll go on to the next slide if you don't mind, Kyle. Okay, so let's talk about trust. A lot of times people also, if they don't call to say I need a will, they say, my neighbor said I need a trust. And I say, well, what do you need a trust for? What type? And I don't know, my neighbor said I need a trust. So in any event, there are so many different types of trusts. And it really depends on your specific situation. So when we work with clients, we require an intake form to be completed as best you can, because that's how we get the information that's needed to give you proper guidance. What is the family situation? What's your income? What are your assets? What are your care needs now and anticipated in the future based on whatever's going on now? So all of that gets factored in. Some people may do just a probate avoidance plan. They're in full control during their life. They say who the assets pass to on when they die. You can avoid the cost and delay of the probate process. And if you have, real estate, the cost goes up because you need a formal probate. So you're going to avoid the cost and the delay. It can take a year or so for probate. And it remains private by not going through the probate court. So we can do a revocable trust as part of that plan if your goal is probate avoidance. Some people want to protect some assets. So that's what we call an asset protection plan. That involves something irrevocable. In this case, we'll talk about an irrevocable trust, but there are other ways to accomplish that irrevocable planning. But I want you to understand that there are ads on the radio. There are ads that make you think that this is no big deal. Hey, protect all your assets with this trust and be in full control. I'm sorry, I don't agree with that. You are giving up control of something to start that 5-year clock. And I'm presuming you all know what that is, but anytime somebody applies for nursing home coverage by Mass Health, which is Medicaid is the federal name, Mass Health is what we call it here. If you're applying for Mass Health for nursing home coverage, Mass Health is going to look at the previous 5 years to see if you gave away assets during that time. It's called the 5-year look back. If you gave away assets for less than fair market value, they will impose a penalty based on the total value of what you gave away in that 5 years. So when people deliberately want to do asset protection, they are moving something out of their name, and they know they have to get through a 5-year period before that's fully protected. And we'll get into that a little more later. That could be a whole seminar in itself on all the ways to do asset protection. But what I want you to understand is it is a big deal. There are risks involved. You have to have full, complete trust in whoever you work with on this plan. If you take nothing else away from today, understand that. So let's go to the next slide, please. Other reasons we might do a trust is because we have a beneficiary with some sort of issues. This might be a spending issue. They can't keep $1 in their pocket. They get $1, they spend $2. It might be because there's some sort of addiction, gambling, alcohol, drugs. Drug addiction is just rampant. I see this more and more. It is such a big issue. So you can leave, let's say you have 3 children and you want to leave your estate equal to your 3 children, but you don't want your child who has some sort of addiction or gambling or spendthrift problem to just blow it, because you want it to benefit them for their life. We can direct that share to a type of trust based on their needs, where they benefit from their full share, but they don't have full access and control. So one of those is a spendthrift trust. That would be someone that, again, some sort of addiction, they can't manage their own funds. Well, you're going to name who's the trustee. The trustee has full discretion to give that person cash if they're doing well. You know, maybe we have someone who had some addiction issues, but they've been in recovery a long time and today they're doing fine. The trustee has the discretion to give them funds outright. But if they're not doing fine, they can say, I can't give you that money, but I will pay this bill and this bill and this bill for you, or I will pay for you to go to that recovery place or whatever. Full discretion in the trustee. You have to fully trust whoever you name as the trustee, obviously. The other thing is you name contingent beneficiaries. So if something happens to the primary beneficiary and there are funds left, you're spelling out in your plan where those funds go at that point in time. Another really important thing with these types of trusts, because it can be a little adversarial, the beneficiary. So if you have, say, 2 brothers or 2 sisters, or a sister and brother, and one of them is the beneficiary of this trust and the other is the trustee, this can create hostility when they have to say, I can't give you those funds. You don't want to set it up so that you further break down the relationship between the kids. So we make sure the client names an alternate or successor trustee. And if there isn't an appropriate person to name, it might be an attorney or another professional. At the very least, we include a mechanism to name some other independent trustee. If that family trustee needs to get out, we're giving them a way out. So all of these things, this is another area where it's not do it yourself. This is something where you really should have legal guidance to spell out and make sure this is done correctly. Can we go to the next slide? All right, next is a beneficiary with special needs. Let's say you have 3 children. Mary has Down syndrome. She has special needs and likely has some public benefits as a result. She can't have a spendthrift trust where she can have the cash directly. What we want for in that situation is what we call a supplemental needs trust. You also hear special needs trust, SNIT. It goes by several names. This is for a special needs beneficiary. It's irrevocable, but it typically doesn't get funded until you pass. So your will or revocable trust is going to say equal to my children, but Mary's share to the trustee of her SNT. That's going to provide that her benefits stay in place, but you're giving her her share to supplement her quality of life, provide as much independence and dignity by whatever added benefits and supplemental benefits these funds can provide for her, in addition to the benefits she has in place. There are strict distribution requirements. It can't pay for housing typically. And that's because typically a beneficiary under these certain conditions can receive housing benefits. So it's not going to pay for benefits that the person already has. So this is another area, it's not do it yourself. The trustee should get some guidance on how do I properly fulfill my role as trustee? What is appropriate, what is not? So an elder law attorney can provide some guidance on that. There's different ways to fund a supplemental needs trust. If you leave a share to your child in your estate plan, that's third-party funded. That means it wasn't funded with the beneficiary's money. It was by some third party, being you. When you have a third party SNID or supplemental needs trust, you don't need a payback to Mass Health or for public benefits. But let's say your child came into some funds directly, they could fund a supplemental needs trust themselves, but that is now what we call first party funded. It was funded with the beneficiary's money. So that first party funded trust must have a payback provision. They allow the beneficiary to enjoy all the benefits during life of the supplemental quality these funds can provide, but they're first in line to get paid back on the beneficiary's death. So you have to be careful on not putting the beneficiary's funds into a third party trust, etc. Next slide. So I would just point out, if you have questions, we'll save them till the end, but that was sort of the laying the foundation portion. And now we're going to talk about optimizing care dollars. When we have a diagnosis, Alzheimer's, other dementias, Parkinson's, MS, so many other chronic conditions, typically they're coming with care needs that are just going to increase over time. So it's good to be proactive in doing the planning before there's a crisis. We have a diagnosis, let's get our affairs in order, let's lay the foundation, let's become informed on what kind of benefits are out there. Even if I don't need hands-on care today, there's a good chance I will need it, or your loved one will. So let's become familiar with all the benefits programs out there and the resources. It's kind of like a puzzle at this point. There are many different sources of resources and benefits. Understanding what's out there and how we can piece together as much care as possible when it's needed. Excuse me, one sec. So, and the other thing I stress with clients is sometimes people are resistant to accept care in the home. The way we avoid a nursing home in the long run is to take the supports we need when they're needed. And sometimes that's an uphill battle, but that is so important. Let's start with, if you're 60 or older and you have any care needs, you want to reach out to your local elder services agency. Like South Shore Elder Service, there's many across the state. There's something called the State Home Care Program. And even without getting on Medicaid they can give you anywhere from 6 to 8 hours without you being on Mass Health. It could be a homemaker, it could be Meals on Wheels, it can be a personal care attendant. And even if you have, I think they base it just on income, but if you're not low income, there's still a sliding scale. And it just makes sense to get a little bit in the door. They also have eyes on you to see if you need more help at some point. So I would get tied in with your local elder service agency. If you are a veteran, reach out to your town's veteran services officer. There's one in every town. They can give you some guidance on the different resources available. There's federal VA, but then there are also state benefits, and Massachusetts has some pretty good state benefits. If it's likely you either have care needs or it's likely you will have care needs, I would encourage you as a veteran to get tied in with the VA, get a PCP, a veteran primary care physician assigned to you, and have an exam. Because once you're in the system, you have care needs. Now that VA PCP can order home care. And we're finding, even when elder services caregivers were struggling, didn't have enough caregivers, the VA was doing much better with that. So that's an option. If you have that available to you, get tied into the VA system. Third, I want you to be aware that there are a number of different Mass Health programs. They're not just for low income or no asset people. That's why it's so important to do an assessment of your income, your assets, your family supports. And these many different programs can pay for in-home care. Next slide, please. So who can benefit from community care or community Mass Health? A frail elder that's 60 or older an elder who needs help with at least 2 of the 6 ADLs or activities of daily living: dressing, bathing, transferring up and down from a chair or the bed, ambulation, toileting, and eating, not meal prep, actual eating, or disabled individuals. Now, when we look at disability for Mass Health benefits, the person either went out on disability and got benefits under SSI or SSDI, so they've already got that disability rating from, or they've been deemed disabled by Social Security Administration, or we have to have them deemed disabled by Mass Health as part of the process. Next slide, please. So let's touch on some of the community Mass Health programs. Community Choices, also known as Frail Elder Waiver or FEW. Through the ASAP, that's your local elder service agency. Aging Service Access Point, I believe is what it stands for. That program is paid for by Mass Health Standard. That's the benefit we get in place. Another program is the PCA or Personal Care Attendant Program. We can access that either through Mass Health Standard or another program called Common Health. And we'll get into Common Health. That has no income or asset limit. Sometimes the downside of the PCA program is that you have to hire individuals, or with Common Health. You can't hire from an agency. You can't just call your local elder services and say, hey, I need you to send the caregivers, Monday through Friday between these hours. They have contracts with agencies, but that doesn't work with the PCA program. This third program is a real gem. When it is the solution, it is amazing, but it's not right for everybody. So, and I'll go into it, but each program has its pros and cons. What works for one family may not be the right solution for another family. And I'll get into some detail on that. So PACE stands for Program of All-Inclusive Care for Elders. It is a comprehensive, holistic plan of care. You have to take PACE providers. It covers everything. It has adult day health. It has the doctors, the nurses, the therapist, medication, transportation. It is all-inclusive, truly. And you're not seeing several different doctors that don't communicate with one another. There is a plan of care. It's a team approach for every person who's enrolled in PACE. The whole team is meeting, whether it's monthly or quarterly or whatever, saying, where are we at with this person? What do they need? Do they need more supports? You can get PACE in your home. You can get PACE. The goal of PACE is to keep you out of a nursing home. So if you are in a nursing home, it's too late to get enrolled in the PACE program. The biggest thing I would highlight with the PACE program, if we have a married couple living in say they're still in their home, one of them has care needs, PACE has a spousal waiver. So if we got the person needing services, say the wife needs some care and services, we can get her in the PACE program by moving all the assets to the husband, and they waive the assets. It's amazing. And PACE is just, I've had my own family in it. I can't say enough about it. It's a wonderful program. Say it's not the right fit for everybody. Say somebody is really attached to certain doctors and they don't want to switch. PACE isn't going to work because it's all-inclusive. You are using PACE providers. Sometimes clients will say, or I'll be speaking to an adult son or daughter, and they'll say, Mom won't switch from Dr. So-and-so. Well, when was the last time they actually saw Dr. So-and-so? Well, 5 years ago. So we have the discussion to try to really go over the pros and cons and the obstacles to see if this would work. Let's see, let's go on to the next slide. Another program called Adult Foster Care. We can access this through either Mass Health Standard or Common Health. Adult foster care, the parent or the person needing care has to live with the caregiver. It could be in the parent's home, it could be in the child's home, but they have to live together. And depending on how much care the person needs. There's two different levels, a level 1, a level 2. It's around 750 or 1,500 based on the level of care. And unlike the PCA program where the caregiver gets $19.10 an hour paid by the state, and it is taxable income, they get a 1099 every year. This is a tax-free stipend. So when we talk about the pros and cons of each program, I've had cases where there's a disabled child who's actually providing the care and they're on SSDI and have an income earnings limit themselves. They don't want to take the earnings. They would rather a tax-free stipend. So that's just an example. This program will not pay the spouse, a parent, or a legal guardian. So anybody but those people. And next slide, please. So going over some of the things that Mass Health benefits will include. The home health aides or the PCA's personal care attendants, people to provide help with those personal needs. Adult day health, going to a medical model. It's not at the senior center. There's a nurse on staff. If there's a medical issue, there's help available. Socialization, transportation to and from is included. That can be not only a really important benefit for the person needing care, but if there's a spouse in the home or a full-time caregiver, like an adult child, they may need some respite. So this adult day health can be a really great piece of the puzzle as well. Again, PACE, the program of all-inclusive care for the elderly, is an option. Community Mass Health will pay deductibles not covered by the person's Medicare coverage or other primary insurance. It'll pay for a Lifeline type device and for prescriptions, and it pays the Medicare D premiums for prescriptions, and co-pays when you have Mass Health, they're as low as $2 to $6. They're nominal. So it's a whole lot of benefit. And next slide, please. So a little more of a deep dive on the Frail Elder Waiver. This is the program that's through your local elder services. Typically, clients get awarded 15 to 30 hours. If, they're wheelchair bound, whatever, we're seeing 40 hours at least. Have to be 60 or older. The waiver, if you have a married couple and the person needing the care, their income is only $1,200 a month, we don't even need the waiver because their income is below what we call the federal poverty level. But if their income is above that, then this Frail Elder Waiver allows us to waive the other spouses, waive the extra income. So even for this, it's sort of the nursing home rules apply for the Frail Elder Waiver as well, but for the transfer penalty. So we have, say, husband, we need to get on Frail Elder Waiver. He can only have $2,000 in assets in his name. The healthier spouse can have up to $154,140. We'll call it $154,000 in countable assets. Not everything counts. The primary residence doesn't count. There's other things we'll look at on the long-term care slide at the end. But the step number one, we can transfer the assets to the healthier spouse. Interspousal transfers are always allowed. And then we have to look at, okay, how are we going to get this couple down within those asset limits? Well, under Community Mass Health, there's no penalty for giving the assets away. So long as there is a trusted person, presumably a child, sibling, whatever, but truly not a distant cousin you've had no contact with. It has to be somebody involved and fully trustworthy. We can have that person hold the excess assets. And it's kind of crazy. We're not hiding them. Mass Health won't approve the benefit until the person is below the asset limit and they allow you to transfer them out of their name. So we transfer the assets to a trusted person, apply and get all the wonderful benefits. Our guidance to anybody we're working with is that trusted person needs to hold those funds segregated, or it's recommended. I'm not saying they have to, but they should hold the funds segregated out of mom or dad's name. but only use those funds for mom or dad and keep really clear documentation. And we'll get into why in a second, but full trust, if nursing home care is needed within 5 years, there's different rules for that program. There is that 5-year look back, and there is a penalty for assets you have given away. So let's say we move the funds to a trusted daughter. She held the funds separate. We got mom on community mass health. And 2 years after we get the community benefit, mom falls, has a stroke, whatever, and is in rehab and can't safely come home. Well, we have a nursing home situation. We had a disqualifying transfer to the daughter. So daughter is going to be able to show, first of all, she's going to put the extra assets that were moved out of mom's name back in mom's name. That's what we call a cure. That's allowed. And she's going to have documentation to show that any money that's no longer there was used solely for mom. That's also a cure because she can document it was used for mom. It was like giving it back to her. So you can take these steps to get the benefits, but it really depends on using trusted people because things can change, and they often do. Circumstances can change. The last thing I would mention on this, there's an automatic estate recovery lien against probate estates in Massachusetts. It's not just for nursing home benefits. So once somebody is getting mass health benefits, you have to be extra sure that nothing is going to go through the probate court because mass health is first in line before your children or other beneficiaries. There's an automatic lien against probate assets. They cannot recover against non-probate assets. So you just have to make sure your assets are not going through probate. Next slide, please. All right, Common Health. This is that program that people think, well, I have high income or I have assets, so I can't get mass health. Not true. Under this program, there's no income limit and no asset limit. It was originally intended for under 65 disabled people, but we've learned it's also available if you're over 65. There's some crazy requirements with it. I don't make the rules, I'm just the messenger. But pros and cons with every program. This one is limited to individuals only. You're going to get PCA services, personal care attendant. You can't call the elder services to find your workers, and you can't call Visiting Angels or Home Instead or another home care agency. You can't hire from an agency. They cannot bill Common Health. It's individuals only. So you have to find individuals who are willing to take the 1099 for that $19.50 an hour that they're going to get. You can pay them something on the side if they're not willing to work for just the $19.50 an hour. And we do see it, unfortunately, since COVID. People went out on their own and they jacked up their own prices. So it's tough. That can be a challenge. This program can be wonderful if there is already a family caregiver or some other caregiver really involved in providing a lot of care or more than one caregiver involved. But if you're just starting from scratch and have to find the caregivers, we'll frequently tell clients, here's how you try to find the caregivers, and let's see if you can find them before we go down this path to apply for this program. It's a complicated application. You want to make sure you're going to realize the benefit at the end of the day. There is a monthly premium based on household income. And sometimes if we have someone with high income, if they're going to get a lot of benefit out of it, it's worth the high monthly premium. But we do that assessment to make sure the cost of it, they'll realize more than the cost of it in benefit every month. So no income or asset limit. There is a one-time spend down based on household income. I'm going to get into this on another slide, but we can waive that one-time spend down with what they call the 10-hour working letter. And I know it sounds crazy, but you have to remember that This started for younger disabled people, working disabled people. But when we use it for like an 85, 90-year-old client who's in their home, maybe they can fold towels, look at your calendar for you, water your plants. It sounds crazy, but if it's something the person can actually do, we submit a letter from the person who's going to be the employer. I so-and-so pay Mary $1 an hour, 10 hours a week to open my mail, whatever it is. And we give counseling on what's realistic, what's not. That allows us to waive that one-time spend down, which typically is thousands of dollars. So it's worth it to do that if we're able to. And again, just bears repeating, again, there's an automatic estate recovery lien against probate assets, whether it's for common health, frail elder waiver, long-term care. It's from age 55 up for any mass health benefits or nursing home at any age. So avoid probate. Okay, next slide. So this is what that spend down looks like if we don't do the working letter. Let's say the person is getting $1,542 a month. There's a mass health deduction of $542. They multiply that times 6. So the income minus 542 times 6, and this is really simplified, it would be household income. So it's going to be much more typically. But under this scenario, you would have to pay the first $6,000 yourself before they would start giving you the benefit. So it's a one-time spend down, you pay up front, then they'll kick in the benefit. With higher income and household income, this can be thousands and thousands of dollars. So it makes a lot more sense to do that working letter when it's a high deductible. Next slide. Exceptions to the spend down, again, that 10-hour working letter, which is 10 hours a week at $1 an hour. Or if somebody had worked full-time in the prior 6 months, then became disabled, it's the 240. It's like 240 hours. So don't get bogged down in those details. I just didn't want to include these details, but you would be getting guidance on that. Next slide. So just to go over it again, kind of the differences with common health, it can be used for under 65, over 65, disabled. There's no asset limit, no income limit, and there's a monthly premium in all cases. For mass health standard, there's an asset limit of $2,000. An income, this is for an individual, an income limit of $2,829 gross monthly income. And the frail elder waiver waives the wealth spouse's income and allows countable assets up to $154,140. But again, we can just move the assets out of that person's name if there's a trusted person. Okay, we're going to shift next slide to long-term care mass health. This is what nobody wants. It's our worst case scenario, but it's smart to know how it works. What's available? Are there steps we can take now in case that ever happens? So long-term care mass health is the benefit program that pays for nursing home only. The applicant can only have $2,000 or less in assets in their name. Their income gets paid to the facility. We'll go over that. The community spouse can have $154,140. The primary residence is non-countable when there's a community spouse. They do have an equity exclusion limit, so you can't have a $5 million home. They're going to exclude up to $1,071,000. There is a 5-year look back under this program, and they're looking to see if you gave your money away in that previous 5 years. They will tally up the total and they impose a penalty. So let's talk about, we talked a lot about community mass health. Let's say we made a client eligible for the frail elder waiver 2 years ago. We moved her excess assets to her trusted daughter. Daughter held those assets in a separate account, the mom account that wasn't in mom's name. There was no penalty to do that under that frail elder waiver program, right? So there was no penalty. But now it's 2 years later. We know there's going to be a 5-year look back because mom's in a nursing home now. So they're going to capture that gift to the daughter. What we do at that point, the daughter's going to put the remaining funds back in mom's name. That's a cure. And she's going to show Mass Health that the funds that aren't there to put back in mom's name were used solely for mom. So we gave clear instruction back when that transfer was made. We talked about, is there full trust? We instruct the daughter how to keep the funds segregated, document everything very clearly. Don't mingle your funds with mom's. Don't use these funds for anyone but mom. So this is not going to be a crisis because we can fix it at this point, put it back in mom's name, show that the rest was used for mom, and we're going to be able to get that long-term benefit for mom. But let's say the assets went to a less than trustworthy daughter or son or whatever, and the funds are gone, or some of the funds are gone. Well, now we have a problem because Mass Health is going to impose a penalty or disqualification period. They won't cover mom for a period of time based on how much we can't explain or how much is missing. And so there's a penalty, and mom is the one who suffers at the end of the day because her application will be denied. Next slide, please. So this is just a brief summary of the long-term care rules for a married couple. On the right, you have the nursing home spouse. They can keep only up to $2,000 in assets in their name. The community spouse can have $154,140. And that's what's called the CSRA, the Community Spouse Resource Allowance. And again, there's never a penalty to transfer between spouses. So the first step is to take it all out of the nursing home spouse's name, except for one account where their income goes. The rest goes to the community spouse, and then we deal with the asset limits. The primary residence is exempt as long as the equity doesn't exceed that limit we just mentioned. One vehicle is exempt. As far as income, the nursing home spouse's monthly income will get paid to the nursing home, less allowed deductions. The deductions that are allowed are $70-80 a month for that nursing home spouse. It's called a personal needs allowance, or PNA, for the barber shop or whatever. Medical deductions, they want you to keep their coverage in place. So the Medicare, the supplemental Blue Cross MedX, their Med D, you keep paying those. It comes out of their monthly income. Medicaid becomes the payer of last resort. They want those other coverages in place, so they allow those deductions. The community spouse's income stays with them. So in some situations, let's say the community spouse only gets $1,555 a month, but they own their home, they have real estate taxes, they have homeowners insurance, water, sewer, maybe there's a mortgage. There's a formula Mass Health is going to use to, first of all, they're going to be entitled as a matter of right to the minimum, the MMMNA you see on the slide. It's a mouthful. It stands for, oh boy, minimum monthly maintenance needs allowance. So if the community spouse's income is $1,555, they're going to be entitled to $1,000 right off the bat of the nursing home spouse's income to bring them up to that minimum monthly maintenance needs allowance. If by plugging those numbers I just mentioned, like mortgage, real estate taxes, homeowners insurance, water, sewer, those numbers go into a formula, and based on their actual expenses, they may be entitled to more of the community spouse's income, up to $3,853.50 to that maximum level. So that's, again, very case specific based on your facts. Other things that are allowed, when one of the spouses is applying for long-term Mass Health, we typically have both spouses get a prepaid burial, pay for it up front, spell out everything that they want. You know, it's all itemized and they're paying up front. They can also get a $1,500 burial savings account. That's for things like, I think they call it a collation, the after funeral party. or other miscellaneous things. They don't allow flowers to be part of the prepaid burial contract anymore, so it can pay for flowers and stuff. The key with that is to make it's up to $1,500 for each spouse. You want to make sure there is a paid transfer on death beneficiary on that savings account, because otherwise it's going to go through probate. And guess who's first? Mass Health is first in line. So it's important to avoid probate with that account. But it's a way to, protect another $3,000 total. Whole life insurance policies count to the extent that they have cash surrender value. So a face policy up to $1,500 is non-countable, that's exempt. Over $1,500 is included in the cap. So if they have a few policies and one is $1,500, well, that face policy, that's exempt. But the other ones, you're going to look at what's the cash surrender value. They look at that. You have access and control of that cash surrender value. So we have to factor that in as if it's a bank account. It's money they have access to. So we look at the total assets, including cash surrender value. A tip on that as well, we typically will have people get an updated policy statement, because if we have a policy that is $5,000 face value or current cash surrender value, but worth $15,000 death benefit, well, they're going to lose $10,000 if they cash that in. We might look at what's the total cost of the burial based on those exact numbers. It might make sense to assign it to the funeral home to pay for that prepaid burial. Or if it's too much differential that we'd be losing by cashing in, and it's more than the burial costs, sometimes a family member has the resources and they can purchase it for the current cash surrender value. They become the new owner. The parent or the applicant is still the insured, and then the person who purchases it becomes the new beneficiary. So they're paying the current cash surrender value, but they'll get the death benefit. So you're not losing that huge gap. That's really getting in the weeds. I apologize, but I just want to mention it because I was thinking of it. So, and then term life insurance is exempt. Okay, well, next slide, please. Next slide. Okay, for an individual, you don't have the spousal protections anymore. So we can't have 154,000, we can only have 2,000. And the primary residence now counts. Can still have a vehicle. You can't go out and buy a brand new BMW and call it exempt. But if they had a vehicle, they can keep it. Their savings accounts, retirement accounts, IRAs, 401ks, they count. In some states, they do not count. Here they do. Stocks, bonds, savings bonds. Sometimes people forget about savings bonds, and there's like a stack of them. So they have to be dealt with. If there's a second home, investment property, or vacation home. Tools of the trade. This is something that doesn't count, but I've yet to see it in my 25-year career. If somebody's in a nursing home, they're typically don't have a trade anymore, but tools of the trade don't count. Prepaid burial savings account, life insurance less than $1,500. So these are the things that are exempt. So those are the rules. There are exemptions. Now, if we have, even though the primary residence becomes countable if there's no community spouse, there are exemptions where we could deed it to a disabled child, a sibling who had an ownership interest and has resided there. I think it's for a 2-year period prior. Or an adult caregiver child. So if the child has lived with the parent for at least 2 years and provided care without which the person would have been in a nursing home sooner, there are verifications we have to get to meet any of these exemptions. But these are ways we can protect those properties. Also, if property is rental property, there are ways we can minimize the cost of care. It's not that they're totally exempt. Mass Health will place a lien, but we can get coverage in place, and the recovery at the end of the day will be at the Mass Health rate of reimbursement, not the private pay rate. So that's a big savings. again, these things require a really specific assessment based on your specific needs. Okay, next slide. We're going to go to questions in a sec, but I want you to know to find an elder law attorney near you. I mentioned I'm president of NALA right now, National Academy of Elder Law Attorneys. We have a find an attorney search function on the website. You can search by zip code, or if you have a loved one in another state, you can search for them. I feel like it would be malpractice not to be a member of NALA. It's wouldn't be, but I think the laws change so quickly, you just really need to be up to date, and NALA's the way to do that. If you're looking for an attorney, you can also check the NELF website to know that elder law attorneys have taken an added step to become a certified elder law attorney. It's like a separate bar exam focused on elder law, all the areas that it encompasses. And also we offer a complimentary consultation. We'd review your situation, income, assets, family dynamics, clinical needs, goals, review your current documents, let you know if we recommend any updates. So just know that that's available. And I think that brings us to questions, Kyle. Oh, also, yes. We know that the Dementia Care Collaborative is funded with some grants, but also by donations. So I would just highlight that, you know, the great work that they do. So keep them in mind for your charitable giving.
Judy, thank you so much for that fantastic presentation. And as a reminder to everyone, tomorrow you will be getting an email with a copy of the slides. So all of this wonderful information you'll have at your fingertips. We will go to questions now. Remember, if you have any questions, please put them in the chat. Our first question is, who are the PACE providers and what are their affiliations?
So there's a number of PACE centers, like Harbor Health. Their affiliation is they are a PACE, Elder Service Plan is what they're called. Based on your location, I could guide you to a specific one, but when you say what are their affiliations, I'm not sure what you mean. They have contracts with certain providers at different levels. So the one that I work most frequently with, Harbor Health in Dorchester. So for my client in their catchment area, they would have contracts with certain assisted living facilities, certain nursing homes. They would cover the homes in that geographic area. Beyond that, I need clarification of what they're asking.
Great. And if that didn't answer your question, feel free to put your clarification in the chat and we'll come back to it. Oh, let's see. Here's some clarification. We're on the North Shore. All of our physicians are at MGH, just trying to get a handle of the level of transition that would be involved.
Yeah, so that would be a discussion to have with the PACE provider in your area, and I can point you to it after the fact if you want to shoot an email. But that would be a discussion with them. So for some people, it's important to stay hooked in with where they are. For some, there are exceptions made, but that's a discussion with that PACE center. And it has to be a good reason, you know.
Great. Our next question, can you please talk a little more about the difference between an elder law attorney and an estate planning attorney? What does an elder law attorney do for elders?
Sure. So it's really, we do a lot of estate planning, but a huge part of our clientele is older adults and people with disabilities. We have younger clients too, but I think it's an awareness of the specific issues that arise with people as they age, as they have some certain diagnoses that are common, dementias, Parkinson's, ALS, I'm seeing a lot of, MS. So as we age or based on conditions, having care needs, maybe needing the resources, the estate plan really has to factor in those specific circumstances. So clinical needs, family situation, it's really just an understanding of those specific issues that come along with aging, disability diagnoses. And it's not exclusive one or the other. It's like a pie chart where they overlap.
Great. And there was another part of that question which you might have touched upon. And also, what does an elder law attorney do for adult children who may be stepping in more proactively as their parents age or have diagnoses?
Yeah, well, it's frequently the adult children are coming in for the appointment, unless, they're coming in as healthcare proxy power of attorney and mom or dad no longer has capacity, then mom or dad is the client. It's giving guidance. So our loyalty is always to the elder, sort of, even if you're acting as power of attorney or healthcare proxy, we're giving you guidance on how to fulfill your role. You have a duty of loyalty and acting in their best interest. And how do we help you get the services or benefits or whatever that they may need? It's really case management. So we have the law firm and we have an ancillary business senior resource center where we have case management. So you have case managers at Mass General and wherever, but this is a little different. This is kind of helping you with questions. I can't find caregivers, or mom needs more care and this isn't working out, or we might need a different program. It's that kind of guidance I don't know if I answered the question.
Yeah, I think you did. Thank you, Judy. So Medicaid and Mass Health would not take the payment from a term life insurance in the case of someone on Medicaid in a nursing home.
So no, and they're not going to take the assets in any event. That's kind of a myth. They don't come and take your assets. There's an assessment of your application. Some things are countable, some are not. Term life insurance is not countable. So they're not going to require that to be liquidated or anything. That's off the charts. It's non-countable.
And are the spouse's IRA and 401k factored for in assessment limits?
Yep. Fully countable. In some states, they're not. Here they are.
Right. Those are all the questions we have in the chat right now. If you have any more, please put them in while we still have some time to address them.
Yeah, let me just elaborate on that. So that can be a little tricky. When clients come in, I said there's pros and cons to each of the in-home care programs. And there's also this assessment required with the nursing home program. So when, let's say the husband is going in the nursing home, he has a really large IRA, we can transfer assets to the wife, the community spouse, as step one, right? But when those assets are retirement assets, you'd be taking a huge tax hit up front to move them to the other spouse. That is something that has to be factored in. It is so important at every point in our discussions and assessment to talk about prognosis. If somebody's declining and failing to thrive and we don't expect them to need nursing home coverage for a long time, I'm not going to have somebody cash in IRAs and take the tax hit for a very brief period of Mass Health. So I just wanted to elaborate on that since they brought it up. And even in the community Mass Health, say the person who needs care, or either one, there's a large IRA. We don't want to get down to that 154,000 by cashing in IRAs. That's a case where we look to common health instead, since there's no asset limit. There's no income or asset limit for common health. So if we don't want to take a big tax hit to get down to the asset limit, but we have to be sure that we can work with individual caregivers, that we can find the caregivers. Just another example.
Thank you so much. These examples are invaluable. As you said, every case is individual and different, but it's helpful to know these specifics. We don't have any other questions yet. So while we're waiting to see if someone enters another one, I just want to thank Judy again for this wonderful presentation. And so not only will you be getting the slides tomorrow, but in about a week or two, the recording of this will be up on our website as well so that you can review that. And also, I just wanted to let people be aware tomorrow when you get the copy of the slides, you'll also be getting an evaluation for this program. And I please ask that you take the few minutes to complete it. It's not only helpful to give feedback to Judy for her presentation, but also for us as we think about our programming going forward as well. And just a plug for some of our next activities. So our August Health and Resilience event will be on the 6th, and that's with Emily Kessler, who will be speaking about relax and rejuvenate with breathwork and a guided meditation. And our next conversations with caregivers will be on August 20th, and that will be with Dr. Olivia Okereke, which is the evaluation and treatment of anxiety and depression of older adults with cognitive impairment or dementia. Let me see if we...
And Kyle, I just want to say, I've looked through the past presentations. You guys have so many phenomenal resources there that people should take the time to explore and take the time to look at if they're dealing with these issues.
Thank you so much, Judy. Yes, and so we have past years presentations as well. So feel free to look at those. I'm not seeing any other questions. Judy, any final thoughts or anything you wanted to share?
No, thank you all for the great work you do. Thank you for the opportunity to be with you again. Again, we offer a consult. If you have any questions, reach out to me by email. If you want to be added to our monthly newsletter or with notice of other webinars or whatever, feel free to shoot me an email. We field questions, reach out.
Great. And thank you all for joining us this evening. And Judy, you're getting lots of thank yous in the chat. So I hope you're able to see them.
Thank you all for joining in this heat.
Have a great night, everyone.
All right. Thank you, Kyle. And thank you to Chris.